Elements of a Contract by Patrick Urbanowicz and Spencer Rosenau. So let's start off by defining a contract. A contract is a written or spoken agreement, especially one concerning employment, sales, or tenancy, that is intended to be enforceable by law.
There are two types of contracts. One's unilateral, which is one side making a promise. Second is bilateral, which is both sides offering something to each other or making a promise. An express contract is implied by writing, whether it be email, letter, or text. An implied contract, it derives from the actions, conduct, or circumstances of one or more parties in an agreement. A quasi is an obligation of one party to another party imposed by law, independent of an agreement between the parties.
Now there are four main classes of a contract. There's valid contracts, unenforceable contracts, void contracts, and voidable contracts. For a contract to be valid, it needs all five elements of a contract. We'll talk about those later. An unenforceable contract is a valid contract that the court will not enforce due to a legal reason. A common example of this would be a contract with a minor.
A void contract only needs one element of a contract to be missing. A voidable contract is when the only element missing is the capacity element. There are five elements of a contract to make it valid. These five elements are offer, acceptance, consideration, capacity, and legality.
An offer is a promise in exchange for performance by another party. Inside an offer, there's three parts. The first part is intention. An intention is that the involved party is ready to accept the consequences if he or she does not perform their part of the contract. The second part is communication. Communication is that both parties have discussed in some way the parts of a contract. As soon as the offeree has received or heard terms from the offerer, the communication is complete. The third part of an offer is definite terms. There has to be exact terms listed on who the parties are, what the subject matter is, which is basically what is happening, an exchange or what is being gained by each party, and what is being lost by each party. This is known as benefits and detriments. If any of the three parts are missing, then it is not an offer. For example, advertising doesn't have definite terms for a party because there is no exact person that advertisement is going to. Also, there's something called revocation. The offerer can revoke the offer at any time before the offeree has accepted. An exception to this is irrevocable offers, which are basically firm offers.
The acceptance is the assent to the terms of an offer. The rule followed is the mirror image rule. Affirmative agreement must also have all of the same three parts as the offer does and have the same definite terms. Silence does not mean acceptance. An exception is prior dealings or unilateral contracts. Together, the offer and acceptance create the form of the agreement. Consideration is a benefit which must be bargained for between the parties and is the essential reason for a party entering into a contract. Legal value is money, promise, or forbearance. Fairness is an equal opportunity to negotiate the terms. And legal sufficiency has legal benefits and detriments. Past consideration is something that happened in the past, can't be taken into consideration for a contract now or in the future.
Next, we have capacity. Capacity makes sure that the people signing are at the right state to understand what they are doing and understand the legal implications of the contract. There are two types of capacity. The first one is voidable. Voidable has limited competency, for example, minors, intoxication, or mental health disorders. The second type is void. Void is completely incompetent or adjudicated. An adjudicated incompetent is no longer able to enter into the contract and will be given to the legal guardian that will contract for the incompetent.
The final element is legality. Legality is making sure that the contract does not do something prohibited by law or that is against public policy. There are two types, illegal by law and illegal by public policy. Examples of illegal by law are usury, gambling, and licensing, and examples of illegal by public policy are bribery, defrauding creditors, and contracts to commit a tort or crime. Usually an illegal contract is void. However, if a court finds that it can separate the illegal aspect of the contract from the remainder, the court can permit the legal portion of a contract to stand.
Thanks for listening to our video on elements of a contract. I hope we were able to teach you something new.